Well, thank you very much, Mr. Speaker. Thanks for everyone for coming out here. I can tell this is a prestigious round because we got water, and that's something I don't think I've ever had the pleasure of having. So thanks very much. So what we'd like to propose on our side of the House is that an ideal justice system should not grant suspects the right not to testify in court on the grounds that an answer would be self-incriminating. So we're not saying that the US justice system right now should just pitch the Fifth Amendment out the window, or that historically it should never been passed or anything like that. Just that someone should not be able to say, I refuse to answer this question in a court of law because if I told the truth, that would be self-incriminating.
Could you just give the case statement again without the double negatives?
Well, I actually just did the phrase I just said.
I was standing up.
Okay, well in that case, I'll talk down to you, which is that you shouldn't be allowed to say, I'm not going to answer a question in court on the grounds that it would be self-incriminating.
No implementation, just primitive.
Yeah, sure.
Yeah.
I mean, I guess we can assume that, you know, people are humans in this system, they speak English, things like that, but basically it's normative. So the first argument we want to make on our side of the House deals with citizens' obligations to the justice system. And the first point we're going to make here is that in order to have a functioning justice system, there must be mandatory citizen participation. Sometimes you just need to ensure that you're going to get unbiased people, or a representative cross-section to serve in a jury, or something like this. So this basically means that people, by virtue of living in a society and being part of the social contract, so to speak, in which they give up certain rights in return for protections and a fair arbiter in their disputes, have to give up certain amounts of time, have to give up certain amounts of resources. I can't just say, you know, I'll take the benefits of the justice system, but I just won't pay any taxes because I don't like prisons, or, you know, that I have some kind of right to not be in a jury if I love my job so much. So given that position, what we want to say is that inconvenience is never sufficient to get someone out of these duties. You can assert that maybe, you know, as a card-carrying NRA member, you might have a little bit too much bias to be in a jury in a certain case, but you can't just say, I don't feel like it. What we're going to argue on our side of the House is the fact that you may be incriminated by telling the truth to a court of law, while that might be really, really bad, is also a kind of inconvenience. And I don't see how they can characterize it any differently, and I'd love to see them try.
Alan, you ever been to prison? Would you call prison inconvenient?
Look, yeah, I would, and that's kind of my point here. It's really, really bad, but that doesn't mean it should be okay to say, screw the justice system, screw my duty to tell the truth, I really, really want to protect myself. Like, it's really bad to go to prison, but I mean, if you kill someone, you deserve to go, and I think it's better if we can get that information out of people. So what we want to say is that if, in all these other cases, for example, like if you're testifying against your brother and you really, really don't want him to go to jail because that would be extremely inconvenient because you love him and care about him, you can't just say, that would be really, really awful. He's my friend. I really care about him. I have the right to get out of this duty. Given that brotherly love can't trump this, why should self-love? And they might say that sometimes it does, but they do have to defend those things too. The second point we want to talk about is consistency. Because currently, there are a number of things that suspects have to do to provide courts with information that will actively go against them. If I have certain documents that might be self-incriminating, I can't just say, I'm going to burn them or destroy this evidence. Similarly, I can't even say, I refuse to participate in a lineup exercise. I can't even say that I refuse to give up my blood when DNA evidence could actually put me in jail. These things are really, really bad, but once again, we allow them because we recognize that we have to strike some kind of a balance in the justice system where we demand things of people in order to ensure that we put guilty people in jail and have fair trials and give courts information with which to work. So what we want to say here is that the suspect is not inherently off limits as a source of information for the justice system to work with. It's not like they can just come up here and say, the suspect is sacred, they have all of these protections just because the information is coming from them. So the question in this round is whether or not it would actually aid the system and society overall to give the justice system the opportunity to access the suspect in the way we're talking about. And that leads me to the third point, all of the benefits of not having this prohibition within a court of law. The first one I want to talk about is fairer trials, because when you can have the suspect up there, ask him relevant questions that he's likely to know something about, and you can have him speak to the jury or speak to the judge, you simply give those decision makers more information to work with. The process becomes more fair because they have more meaningful stuff to evaluate, and we think just in general, whichever way that cuts, it's good for the justice system to know. The next thing I want to talk about under fairer trials, though, is the opportunity to meaningfully confront witnesses. Suppose that you're a suspect who's on trial, and your defense is that one of the witnesses who's accusing you actually committed the crime. Under the current justice system, the only way that person is ever going to talk is if you can somehow encourage the justice system to give that person immunity. But there's no reason the justice system, just on a suspect's word, is going to offer someone an immunity because they have a whole lot of risk, and there's no reason to believe they're going to get any good information out of that. On the other hand, if you can actually get your lawyer up there to ask this person who you think did it relevant questions about, how do they know certain things about the crime? Or what was their role? Why were they there? And they can't just say, I refuse to answer these things because they might indicate that I was actually the guilty party. You have a more meaningful ability to confront witnesses against you. And that's also a very, very important right. That said, the next thing I want to talk about at this point is the idea of simply incriminating more guilty people. I know this sounds a little cold, I know this sounds a little obvious, but the bottom line is that when you can ask people who presumably know the most about a crime because they're the suspects, and you can find information about that they only would know and find out whether or not they're guilty, you get all of the benefits of punishing them. But you seem to think that that's not worth it.
I mean, what does it look like to a jury when a person takes the fifth in the first place? Is this really going to make that much of a substantive difference?
Okay, first of all, I'm not really sure where you're going with that. If you're just trying to say, well, the fifth's not that big of a deal because everyone knows it's a sham anyway, I don't really think how that defends making it this really important right in society. But the other thing that I want to say here is that just shows that people are often likely to assume that you have something to hide if you're not coming up there and saying anything. And your point is just that people will often want to come up there and say anything anyway, so I don't see how that really hurts society. What we want to say here is that even if people have some sort of incentive to lie, even if people look really, really uncomfortable, I don't think these things in and of themselves mean that the suspect should be off limits. If the most material witness who's on my side is someone who seems shaky and nervous, they can't just have a free pass on not getting cross-examined by the prosecutor just because they're afraid to look bad. Similarly, I don't think that just because someone who's on trial may themselves be very, very nervous about being incriminated, that something like that should mean that they should just get off. The point here is that even if someone lies, we have the opportunity to work with the things they're saying. We can test their testimony for inconsistencies. We can compare it to other things that were already in the record, such as physical evidence or things that other people said. The point is that getting more of this information out there from a source who presumably knows a whole lot because they're reasonably suspected and might have even had to go through a grand jury indictment can provide a lot of evidence for courts to work with and can get guilty people in prison, and that is a very, very beneficial thing because punishment is obviously very useful to society. So given that this doesn't really hurt innocent people and gets more information into courtrooms and helps the justice system work, we think that the justice system ideally should not recognize this right. Thank you.
Very As thanks Prime Minister for his remarks, now calls on the Honourable Leader of the Opposition, Mr. Mike Palmieri, to deliver a speech not to exceed 8 minutes, deconstructing the government's case. Here.
Okay. So I was going to explain that I'm going to deconstruct the government's case, but that's been done. So, okay, here we go. The basic philosophy we get from Alan is that there's something very, very important about what the justice system does, and anything that sort of interferes with this function and interferes with this, purpose is a problem. And we don't think that on side up. We think that there are certain very, very important exceptions to the functioning of the justice system that we've already carved out in society, and carved out with damn good reason. And we don't see any reason why just because, oh, well, we can get more information. You can get more information if you get rid of a lot of the different procedural safeguards in the justice system. We just simply don't think that all of these ends are worthwhile. So with that said, I'm going to do 3 points. I've been debating in England for a while, so I'm not going to be really critical about blowing and stuff, but whatever. So the first point I want to talk about is limits on the individual commitment to the justice system. Because they look at social contract obligations and they're like, look, you're before trial, you're in the justice system, you have an obligation, you're a citizen, you reap social benefits. I mean, big whoopee shit. There are lots of different things that society can demand of you. Sure, they can demand for you to pay taxes, and they can demand for you to have to actually, abide by the law and, listen to the judgments and decisions of courts. But society, at least liberal society, is not meant to be the be-all and end-all of individual existence. There are certain things that liberal societies cannot demand of their citizens. One such thing that we think that liberal societies cannot demand of their citizens is forcing them to get up on a stand and to crying against themselves. We think that there's a certain right, a certain ability that you should have that's somewhat sacrosanct to be able to say what you want about yourself. And to the point at which you're being not only forced to say something that you don't want to say about yourself, but forced by an organ of government that should in some sense be neutral about what you're doing, being forced to use that to your own detriment, we think that there's something kind of whack about that. Yeah.
You're allowed to say whatever you want, right? I mean, we're not saying that you have to come up and say, I did it, that we're not forcing confessions.
Yeah,
but presumably if you tell lies, that's going to come out.
Right. Yeah, presumably you tell lies are going to come out, but that's not the point. The point is you are forcing a person to make some sort of positive statement, not just positive in the good sense, but positive like I did this or did not do this. You're forcing them to make some sort of confession about themselves, and we think that there are certain spheres just into which the liberal state has no right in going, and this is one of those spheres. Now let's look at an analogy, and this is my second point, about other types of privileged relationships. Between a husband and a wife, between a priest and a penitent, between a doctor and his patients, or between a lawyer and his clients. All of these are really, really important social relationships that we want to deem as privileged and deemed outside the view of the court, and outside the purview of what courts can admissibly drag into court. So to the point at which we see, look, we already have limits on what the state can do in its fact-finding power because we've accepted all of the things that go on in these relationships. Why is the relationship between the individual, why is my own internal monologue of what I am and how I am why is that in some way different? Don't we think that that relationship or that conception of self is at least in some way just as valuable as the other sorts of social relationships and should be just as immune from being dragged out into court? They're like, no. You can get a lot more information this way. And my third point is going to be, I don't really think you're losing that much more information. I rose down a point now and I asked, like, what does it look like when someone rises in court and says, I take the fifth? When someone rises in court and says that, they look like a schmuck. They look like they have something to hide and that they're being duplicitous. Yeah, you're losing some information, sure, but you are also sending a powerful message to the jury. And to the point in which the jury is trying to find fact, and there's also information that may corroborate or discredit this witness from other places, the jury is much less likely to view this testimony as credible in light of the fact that the witness took the fifth. So even though you might not get dispositive evidence every time out of this particular witness, or you might not reap the maximum amount of information that you can get from this guy, putting this admission, this idea in the jury's head that this guy cannot be credible in light of all of the other information that's been brought up in the trial process, you're probably not losing a whole hell of a lot in terms of bringing about fairer trials and all of these benefits that Alan is talking about in his side of the house. So with that said, I'm going to go through their 3 points. So they talk about first that there is this obligation to the justice system, mandatory citizen participation, because you've consented to this. But let's think about who's actually being brought to trial in most parts of the real, at least in the United States. Who's actually being brought to trial a lot? It's not like you're people who are in the lawmaking class. The people who are being brought to trial are not lawyers. They're not like bourgeois people who vote and go out and shape social laws. They're largely people who were born into a society and like, I was chose to born into the society, I signed the social contract. Bullshit. You didn't sign the social contract. You were largely born into these circumstances and were forced to accept them. And we accept that because, in large part, people have the opportunity to affect societal legal processes, to affect law and legislation process, and they can make that social contract in the society in which they live in some sense, try to conform to their own views and interests. But by and large, the people who get brought before the criminal justice system are not those people. Largely, they've been politically, economically, and socially disenfranchised in society, and a lot of their crime is a result of that. So when you want to talk about obligations to the court, you need to start thinking about whether there's any real kind of rich consent that these people have given to the legal system in the first place, or really whether it's something that's just imposed on them from society above. Yeah.
I wonder if this is also supposed to be an argument for exempting anybody who may be brought before court from taxes, from subpoenas.
No, it's not an argument for that. We realize there are certain social goods that society needs to provide and that we can't have people opting out by saying, you know, I really didn't consent to that. That's not the case at all. But what we're saying was when you are forcing someone to come into court and to cry against themselves, and when there's no real practical loss in terms of information, I think that that point, when we're not talking about absolutes but are talking about thresholds, I think that that's a sacrifice of information that we're more than justified in making. The second point that they bring up on side government is just about consistency. And this is really just sort of a laundry list of good things that come from their side. And we admit, yeah, their side is going to get more information because their side is going to force people to say what they're supposed to say under penalties of perjury in court. But so what? We think that for all the reasons that I told you before, the mere fact that you're getting marginally more information that can probably be got at through implication in other ways, is not sufficient to vote for their side. And the final point that they bring up has to do with fairer trials. They say that you're going to force this person to confront witnesses. Well, first of all, we don't necessarily think that's the case insofar as right now you can't force somebody to testify when they're being dragged into court to defend themselves. You can't force them to testify at all. So how is this in any way going to force them to confront witnesses any more than the status quo? But they just reiterate the same thing again about how more information is going to mean more guilty people. Well, maybe. Maybe it will. But we think that there are certain costs we want to bear, and that their liberal state means certain things about what we may rightly force the individual to do, and the spheres in the individual's lives in which we may not rightly interfere. And because we feel that even though you might get some more information, you might get more guilty verdicts on their side of the house, in terms of what the society is doing to the individual, it is just far too high a price to pay. For these reasons, we oppose.
As thanks for the opposition, it now calls on the Minister of Government, Mr. Dan Greco, to reconstruct the government's case.
Thanks, Mr. Speaker. Thanks to everybody for coming to watch, and thanks to you guys for coming. I haven't seen you guys in a while, so that's good. So with that being said, I'm going to get into the things that Mikey talks about. And the first thing, really the first 2 points, are these basic ideas about how there are limits on what the justice system can do. And the way I took this was as a general sort of anti-utilitarian point. All right, look, sometimes there are policies that would bring about good consequences. Nevertheless, there are still limits on what we can do to individuals to actually bring about those good policies. Now, as a general point, that's fine. I mean, you can agree with that, you can disagree with that. What I think Mikey didn't do very much of was explain why this is one of those particular instances where we should hold this right sacrosanct, right? He basically just says some things are sacrosanct, like the right to plead the fifth, right? And doesn't really explain that much about why the right to plead the fifth is so important. So I want to talk about some of these examples that he gives. He talks about other sorts of privilege. So he says, look, if you're talking to your priest, we can't force the priest to tell a court what you sent to him. Or if you're talking to your lawyer, we can't force the lawyer to tell a court what you sent to him. I actually think there are some great justifications for a lawyer-client privilege, for priest-penitent privilege, and for doctor-patient privilege that do not apply, that make it clear how there's quite a distinction between all those and then the right not to self-incriminate. So what is this distinction? Well, take the example of lawyer-client privilege. Suppose if you went to a lawyer and told him that you were interested in certain things, you knew that that lawyer could then be forced to come and tell a court that you said these things to him. That would definitely deter you from going to talk to a lawyer. It would make people afraid to seek out legal counsel. Same thing goes for a doctor, right? You'd probably be afraid to seek out the counsel of a doctor, especially a psychiatrist, right? You'd be afraid to go and seek out the counsel of a psychiatrist. If you told that psychiatrist certain things that would be incriminating, that wouldn't get more information for the justice system. That would just say that the people who aren't testifying anyway now also aren't going to get psychiatric help, also aren't going to get legal help, also aren't going to even be able to talk to God or talk to priests, if you don't think they talk to God. So I think there are good reasons why we want to protect those privileges, because there are certain relationships that are important. What's the analog for for the right against self-incrimination? That you want to be able to talk to yourself, or that people are going to be afraid of talking to themselves unless they have this right? That makes no sense. There's no way to understand that. I can't even see how you could come up with some sort of analogous justification. I'm surprised that you're standing for this, because it seems like a pretty good point.
It's not necessarily that you're saying that people are going to be disincentivized for engaging in relationships with self, as much as there is still something wrong, although different than the problem with all those other relationships, still something wrong with making the person his own instrument of the state's imposing a punishment on.
Okay, but now the problem is you say, well, actually it's different from all these other cases. Because you gave all these other cases, I said, yes, I like those other cases. Those are good examples of privilege. Why? Because there are these reasons why we want to protect those privileges. Because we want to protect priest-penitent relations, or lawyer-client relations, or doctor-patient relations. And then that's fundamentally different from this case where you gave, where we say, well, but it's still something sacrosanct. The way to explain why it's sacrosanct is not the same way to explain what's so special about all these examples that I gave. So while you can keep saying that there's something really important about it, I do think you knife yourself once you admit that it's not the same thing that's important about all these examples that you gave off case. So the last thing that he says off case, before he gets to Alan's points, is that, well, look, you can get, even if you could, he says, not taking the stand discredits people, right? When people say, I'm going to plead the fifth, then, juries are going to assume that they're guilty, so either way, you're really going to get to convict these people. Now, I'm not really sure which way this is supposed to cut, because if he's saying this, that seems to sort of just be a bad thing for his side too, right? Because even if you don't have to come and testify, you're going to be convicted for that, so people probably are going to come testify. Now, I don't know what the truth is about how much people who actually don't take how much people who plead the fifth are convicted versus people who don't. But I don't see how he's supposed to be using this as offensive material for his side. You can say, look, if people just sort of assume that people who don't take the stand are automatically guilty, maybe that's a bad thing. Maybe we should force them to take the stand and then actually make sure that the information gets to be evaluated, right? I mean, if he's saying that juries are just going to assume that people are guilty, maybe we should be a little bit paternalistic and force people to come take the stand. I'm not willing to assume that people are always going to make the best decisions about whether to take the stand or not, especially if you think, as Mikey does, that, well, if they don't take the stand, they're automatically going to jail. But I would say, even if you think, either way, they're going to jail, it just seems to me that Alan's point about how having more information is just going to be generally better for the justice system still holds, right? Suppose the guy's going to be convicted either way. Okay, well, this way we'll learn about his accomplices, or this way we'll learn where the body is, or other sorts of things. It just seems like all else equal, it's better to have more information. I think we've tried to show you why all else is equal, and I think that Mike's point about how, well, they're going to go to jail anyway, just doesn't really do any work against our side, maybe does some work against his. So with that being said, I'm going to go back to case and look at the arguments that Alan made. So the first thing he talked about was this obligation to serve the justice system. And there was some social contract rhetoric flying back and forth on both sides. If you guys debate, you are going to hear that. Alan likes it, Mikey likes it, well, likes it less. But I think it's just generally a good point to make, right? We just do think it's fair to ask certain things of people. And whether you think of that in terms of the social contract, it's not supposed to be a literal thing, you're not supposed to have had to sign it. It's just generally a good metaphor for thinking about why it's okay to require people to do certain things. And the response that Mikey gives, I just don't think is sort of sufficient to understand what we think it is and isn't okay to ask of people in general in society. What he basically says is that sometimes life is unfair, especially for people who are accused of crimes, right? Especially for people who are forced to be defendants in the context of the criminal justice system. And because life is unfair, it's really not fair for us to sort of assume that there is this kind of social contract-like entity, not fair of us to assume that the obligations that apply to everybody else apply to them. And while I think this can sound nice in the context of a debate round, the implications of it really are far-reaching, right? I mean, what sounded like kind of a joke POI really does seem to be the implication of what he said. That we can't require that people who've gotten shafted, who've gotten the short end of the stick, we can't require that they go to jail when they actually are convicted of things, so that they pay taxes. Well, we have progressive taxation, so we require that they pay less taxes. That's good. But the idea, I think it makes it hard on Mikey's side of the house to sort of explain why it's okay to just require that the same laws apply to everybody, even when some people got the shaft. I think it's fine and good for us to try and address societal injustice, but that doesn't explain why we in the context of addressing that societal injustice, can't demand that people who have been the victims of injustice also appear before court, right? We already can subpoena them, even if they're poor. Sure.
Given that your case is sort of the interest of the justice system superimposed on the interest of individuals, don't you think that the fact that there is not as much consent as your social contract model will want to point out means that you should in some sense discount the interest of the justice systems that you're so quick to promote?
I'm just wondering if you think this applies any differently to self-incrimination than any other aspect of the justice system, like subpoenas, like all that other stuff. Look, I just don't think the right way to address societal injustice is to say that laws don't apply to people who've been victims of societal injustice. I think the best way is through social programs, education, welfare. There's sorts of things that remedy societal injustice, not the sorts of things that say, if you're the victim, then you don't have to follow laws, or you don't have to follow laws as much as everybody else. I think my way of thinking about what to do about societal injustice makes a lot more sense. So the next thing that we talk about is consistency, right? And he just gives all these examples, right? Documents, lineups, DNA. I think these are all good examples that just aren't really responded to. Maybe because there aren't great responses. I mean, it just seems really correct to me that, look, we can try and use the defendant to get information about whether a crime is committed. And whether that information comes in the form of that defendant giving his blood for a DNA test, or giving his testimony for examinations of consistency, seeing how it works and everything else. I think the general principle is that if it is going to make the justice system better, and the costs for the defendant aren't too much, right? We're not torturing people, right? I don't think that's analogous here. Then it's okay for us to do that. And so the last thing that we talk about is benefits. And I think a lot of this is sort of conceded by Mikey because he wants to talk about sort of the way in which, well, even if you get those benefits, right? Even if you get a better trial, even if you get more information, it's not okay for us to do this sort of thing. Now, maybe sometimes that is a good argument, right? I think in the context of, roundabout torture, right? That would be a different sort of thing to say, right? If we got more information from torturing, well, but is it okay to torture people to get that sort of information? Is this too inhumane a thing to do, right? In that case, maybe you could have made arguments as to why torture would have been too inhumane, too much of a bad thing to do to get extra information. I just didn't see the arguments in this case as to why this particular thing, requiring that people testify, the same way that we require that people testify about their brothers or, their really close friends, why this particular thing is so inhumane that it's not worth it to get a better, more fair justice system that convicts more people that deserve to go to jail.
As thanks to the Minister of Government for his remarks, and now calls the member of the opposition, Justin Berkowitz, to deliver a speech, the final constructive speech of the round, not exceeding 8 minutes. Hear, hear.
Thank you for recognizing me. Okay. So I'm a little bit confused because I know Dan, he's got a red shirt, he's not in law school. He doesn't need to know that much about, say, criminal procedure or even have watched an episode of Law & Order. But Alan, I know, has cable, and I know he's seen Law & Order. He also goes to law school, and a pretty good law school, albeit not as good as Columbia Law School, right? But what confuses me about this, and I guess Alan maybe just dozed off in criminal procedure or something, is that there are more than one type of person testifying in trials. Certainly, you may have a defendant testify, although you can't subpoena them and force them to testify, which they don't address on their case. I'll get to that later. But what I do want to mention is there are a lot of other people that testify at trials. They're generally called witnesses, and they provide extra information about this, whether it's helping a state try and meet its evidentiary burden or it's trying to help the defendant by giving an alibi or something like that. It turns out that the overwhelming majority of people, say I don't know, 100% of people who take the Fifth Amendment in trials are not on trial themselves. They're other witnesses. Wait, why would they do that? Well, it's pretty simple. Let's say Alan and I go out tonight and we steal a car. I saw a cool Mercedes out on Broadway. So Alan and I jack the car, and we're driving around. Then Palmieri shows up dead. The next morning, the police come into his apartment, it stinks, and there's Palmieri croaked and no clothing on, and he's got like nipple rings and all kinds of stuff. So we go to trial. First thing they do, or rather that I do when I have the opportunity, I call Alan to the stand. And, or maybe the police call him. They say, Alan, you know, what was the story? Weren't you with Justin? He says, yeah. What were you guys doing? Alan doesn't want to say that we stole the car, because even if he can provide an alibi, he doesn't want to provide the alibi that sends him to prison. Now you might be thinking, well, why not? Well, part of the reason here is we want to give Alan an incentive to come to the trial at all, to say maybe not get subpoenaed or something like that. If Alan knows that he can be forced to, when he gets called in my trial, say that he stole a car, this is going to be a big incentive not to come talk. Now, we were thinking about incentives before. I think actually Dan brought this up. That when he talks about talking to a lawyer, we want to give people an incentive to talk to lawyers. Or we want someone to go to the doctor. I certainly think we want to encourage more people to testify at trial, and by giving additional witnesses the opportunity not to incriminate themselves, we improve the process for the person actually on trial. So that's, when I say the overwhelming majority, I actually just mean all of the cases where this happens. And at that point, I'm a little bit troubled about their case. We'll get to that momentarily, though. Because the first thing I want to talk about is Mike's initial argument about the state effectively having no right to do this. So the first thing I would say is, we're going to address it on their like crazy land world of like the defendant takes the Fifth Amendment. Keep in mind, by the way, that you can't subpoena a defendant and force them to testify, even if it's against themselves or not. Like, you just can't force them to take the stand. It's their choice as to whether or not to testify. It seems that this wasn't part of their case. Their case was, well, you don't have the right to claim the Fifth and say no self-incrimination. So, although they've undercut that right, it seems that they haven't allowed the state to actually force this person to testify. So the outcome is their case does nothing. If I was on the stand, they might be able to force me to testify against myself. Since they have never, ever addressed the idea of actually being able to get me to the stand, the procedure for once I'm there is totally irrelevant. But, Dan wants to change the case. Go on, sir.
You clearly weren't listening. You didn't say the U.S. justice system should get rid of the Fifth. It was clearly set in an abstract context where I think it was pretty clear that, yeah, we were okay with telling people they have to testify. So you can pretend that you didn't understand that in case construct because you're thinking about it in the context of U.S. law. But that's not
right. Well, I am thinking about it in the context of U.S. law, and be a lesson to all of you that when you run an abstract case about a liberal democracy, there are a lot of questions at play, such as, is this a liberal democracy with civil or common law? Is it an inquisitorial system, which happens in liberal democracies? So for them to make any arguments about some type of weird procedural rule here is just kind of silly and moot. It could be just as true as what I'm saying as what Dan is claiming right now. They never clarified it for us. It's true I'm relying on the US, and he could be relying on the liberal democracy of South Africa, where it turns out if you refuse to testify, they just kill you and bill your family for the bullet. Which we also oppose. Okay, so in terms of what I was saying before Crazy Land happened, we also just object to the idea of the state being able to force you to admit you're guilty. Well, why is this the case? First, if it actually could happen, if we take Dan's point as gospel, and the state can force you to be on the stand, they can force you to admit you're guilty, we'll never have a trial again because everyone will always plea bargain. Well, they might say that this is a good thing, it reduces costs. But keep in mind, it also completely throws off any evidentiary burden for the state at all. The whole point of a trial is not to declare someone innocent, it's to determine whether there's even a sliver of evidence that they're innocent. There's a shadow of a doubt, that's the language. The reason is the state has a burden not just to get you up there, but to actually prove you guilty. And at the point where you might as well just plea bargain, the state has no burdens at all, they go out the window. Alternatively though, you are forced to perjure yourself if they can put you on the stand and you can't take the Fifth. At which point the state has an obligation to prosecute you for an additional crime. I don't think it's really fair for the state to put you in a position where either you admit your own guilt or we're going to prosecute you for the additional crime of perjury, which in a lot of cases, say a state with 3 strikes you're outlaws, maybe your liberal democracy has that, means that this is your 3rd felony conviction and now you're going to jail for life. I think that's a little bit unreasonable for 2 car thefts, but obviously since Alan steals lots of cars, he may disagree. Okay, so the very last thing I want to talk about though is, yes. I'll get to Dan's kind of silly point about maybe we could find a body if we force someone to testify on a case. And cases where I'm going first here. So the first thing that they talk about is, well, you know, citizens have an obligation to the justice system. Because, you know, jurors give up their time. It's inconvenient for them, but they have to do it. So, God damn it, it's inconvenient. We don't care if you have to testify against yourself. Alan has apparently never watched an episode of Oz. I have. Jail is more than inconvenient. Jail is a really bad place to be. There's a reason why guys under the age of 21 are like 90% likely to get raped in prison. It's not like Funland where it's inconvenient. It's not like going to NYU Law. It's kind of a pain in the neck. It's like actually terrible. It's like going to Harvard. It's a terrible thing. So first of all, in his sort of balancing equation where he's like, look, justice or inconvenience? Clearly justice wins. Justice, anal rape, I think the scales are just I think it's a lot more reasonable though in terms of a serious argument to balance these things differently. But also, let's consider some other examples that perhaps their liberal democracy in fantasy land may or may not have. A right to search and seizure. Lots of evidence is thrown out because the police collected it in an inappropriate process. It's called the exclusionary rule. Now, back to there, we didn't tell you what kind of weird liberal democracy this is. England doesn't have an exclusionary rule. America thinks this is a good idea. What else? Relevance of past crimes. The government can't say, weren't you convicted of X, Y, and Z, because it tends to actually kind of bias juries against people. The same applies for witnesses on the stand who aren't on trial themselves, that are testifying about what happened. Keep in mind that those people can claim the fifth now. On their side of the house, jurors are automatically perjured because the relevant criminal past or irrelevant criminal past of anyone can come into play. But this is something we value now. We don't allow it to come in, and that's why. Giving notice is a pain in the ass. If any of you eventually go into some type of legal career, you'll understand that the processes of both civil and criminal justice are an enormous pain in the ass. You have to give notice, you have an amount of time, you have pleading requirements. They're all annoying. It would be a lot faster if we just hung you up by your toenails and forced you to admit that you were guilty, but we consider that in violation of the justice that we hold important. So when they're trying to give you some type of balancing mechanism, keep in mind it happens all the time that procedure takes some type of precedence over this bizarre world of getting more answers that they think is particularly important. But we also have a little bit of an undercutting that happens in the MG speech from Dan, because he says, we weigh out things like confessions. We want people to go to their priest and testify. So he admits that this is a good idea, but being able to claim or not testify against yourself is not that important. So if I'm understanding what I thought correctly, it's more important that you talk to your priest than it is, because that he would keep sacrosanct, than it is that you are actually protected from incriminating yourself. To me, this is pretty problematic. I think he kind of shoots himself in the foot. So the other arguments they make here are a sort of general social contract argument to which I give the standard reply. What contract? I don't remember signing any contract, and whose version of the social contract are you talking about? But the last thing I'd say is in any liberal democracy, the goal is to err on the side of rights, and I think a person on trial has substantially heightened rights because of what hangs in the balance for them. The very next thing, though, he says is real good. We don't let people get out of taxes. Everybody has to pay taxes. Apparently, their liberal democracy only lets some people claim the fifth. Our liberal democracy allows anyone to have Fifth Amendment protection. So I'm not sure I understand why they claim that there's some type of unequal application of this, because we're allowing anyone to claim that they have protection. It would be wrong to allow one person to opt out of taxes. It would also be wrong to allow one person to opt out of this. Their case seems to indicate that when the government wants to force you, they can take away this privilege of yours or right of yours. Our case applies it a little bit more in a uniform manner, and we think that's more appropriate. So the next argument is consistency, which is just dumb. And the very last thing that they talk about are fairer trials. I think giving an incentive to have more people come and testify, which is the way this is actually applied in real life, is something that's important. We want to have the most evidence come out as possible. And if you can call additional witnesses because they don't have to worry about themselves going to prison, we think that's really important. That gets you much fairer trials than their side of the house.
As thanks to the member of the opposition and recalls the leader opposition to over a 4-minute speech, reminding him that while new examples are welcome, new arguments are not. Here.
Okay, there have been some sloppy things about whether or not we also, whether we're in the civil law society or what type of liberal democracy we're in, but I'll try to make it as clear as possible. The first thing I want to talk about is the point that Dan makes where he accuses us of a knife on side op, where he's like, look, we believe in protecting all of these other relationships, but you're talking about how this relationship about, within the self, the relationship that you don't want to incriminate yourself, how these differ from all these other relationships. And he thinks that this is in some way, contradictory. But when we talk about why these other relationships are important, when we talk about why husband-wife, lawyer-client, doctor-patient, why all of these things are important, that's merely to testify to the fact that, look, there are limits placed on the good that they are trying to pursue on their side of the house, namely more information or whatever they're trying to do about the fact-finding process within trials. But what we've been saying consistently is that there are other harms which are similar, but not necessarily exactly the same to the harms of, not protecting those relationships. Justin talks about the harms of not having other material witnesses come forward in trial. I talk about the harms of the limits of this liberal state, that there are only certain things that the liberal state can require of individuals, and this thing goes above and beyond that. So just because there are different sorts of harms from these different relationships, that doesn't mean it's inconsistent. So, what is exactly wrong with forced testimony? We think there are a bunch of things, and we're going to give their side the benefit of the doubt in some sense too. Let's say, fine, let's say we're talking about not America, we're talking about places where you are bringing individuals, defendants, up on the stand, and you're taking away their Fifth Amendment right. If you're taking away individual defendants' Fifth Amendment right, we don't really think, first of all, that that's getting you more information on their side of the house, because we talked about how there's already a lot of other information out there. They're essentially there to certify and to corroborate other information and testimony that's already been given. And to the point at which they take the Fifth and look less credible in the jury's eyes, you probably achieve much of the same results anyway. But if we talk about their goal of getting more information in fairer trials, and now take into effect, as Justin says, that what you're also doing is disincentivizing other jurors from coming forward because they don't want to have to say in open court that they did another crime that is different from the one at trial, but is still pretty damn important. I think what you're also doing is you're limiting another important factor and another important source of information to the trial. And if you're talking about more information, and if you're talking about fairer decisions, and if you're talking about just a better trial process that gives better results for society, I think their side is actually losing out. But I think the other thing that we want to talk about is just what you can expect of the individual and just how much you can hold the individual to. Justin talks about how hard it is to say that a person who has, committed one crime and now has to admit to that crime under penalties of perjury, particularly in states with 3 strikes laws, suddenly you're really close to life in prison. We think that there are certain punishments that come along with these sorts of things that are very, very harsh and that they don't really understand and they don't really appreciate just how restrictive these are on individuals. But let's look at what liberalism actually means. Liberalism actually means that there are limits to the state and its relationship with the individual. This liberal state cannot compel a person to speak. They can't compel a person to say anything that the state wants them to say. So why can they compel a person to go into court and on penalties of perjury say something and something that's going to get them thrown in prison? It's not even just the fact that they're aiding justice or anything like that. It's the fact that they're forcing a person to say something that not in court they wouldn't necessarily have an opportunity to say. But moreover, now they're holding a penalty over their head for saying it. They're holding 2 penalties in the case of perjury as an option. So the point at which they're exercising that level of control and that level of power over an individual, we think that that's just not allowed under the liberal state. We think that, the type of consent, the type of things that they're talking about with social contract obligations really don't apply as strongly as they want them to. We're not saying that it's a free-for-all where people can just cry poverty and get out of the law. But we really have to say when we're holding these strict punishments over people and when we're holding people accountable to society to this level where they're being forced to confess in front of open court on penalty of perjury, to the point at which we're requiring that of people, just how much do we have to take into account the fact that the law isn't always fair? That's not an excuse, but that means that there's probably a certain limit of what we can expect of people to do in the court of law. So for those reasons, we oppose.
Senate thanks the lead opposition, and who calls the Prime Minister to deliver the final speech of the round? Here.
Thank you once again, Mr. Speaker, and everyone for making this an interesting round. I want to start where I started off initially with this idea of citizens' obligations, because I think this is one of the fundamental ways in which we have won this round. What I said in the beginning, and what Dan very cleverly extended, was this idea that the social contract is a figurative way of conceptualizing the relationship between people and their government. Saying, I didn't sign a piece of paper that says social contract on it, isn't a response, in the same way that if I got up here and said, you can't use examples on Oz, that's not a real prison, or prison isn't really hell, you can't make figurative points in this round. No, clearly this is just a way of conceding of this relationship. So just saying you didn't sign it is an incredibly silly thing. But what is also silly is this idea that most suspects are poor and uneducated. They are effectively disenfranchised. Therefore, for some reason, that means that the entire justice system should sort of be less applicable to these people. What I would say is that there are important distinctions to be made here. Progressive taxation might be fine because there are relevant reasons why we don't want to screw someone out of their income when they're hardly making any to live off of. Or it might be fine to say that we shouldn't apply punishment too much on you if you were really, really stupid and couldn't conceive of the decisions you were making or had problems with being culpable. But just saying that these people are poor and are in worse position in society would be a reason to completely exempt them according to their side of the house. And I think it's really, really silly to just say that therefore there isn't a social contract. It seems like the principle they're trying to espouse here is that when there is more at stake, when it is more dangerous to you to actually tell the truth and aid the justice system, somehow that means you should get off. Like the entire justice system should be a sliding scale. I'm a really rich guy, my life is really, really good, so therefore it should be really easy to apply it to me. But I'm poor, so therefore the standard of reasonable doubt suddenly goes up to 99.9%. Clearly we don't do that. We don't even have different standards of proof, we do have different standards between criminal and civil trials, but we don't just say, there's more at stake in this trial, you really have to prove this guy is guilty, this is just a shoplifting trial, 51% evidence is enough. We clearly don't really buy into this principle here, so I think they're really resting on shaky ground when they say that citizens don't have some obligation. They can get up here and talk all they want about how prison is a very, very terrible place. All that says is it's bad to be punished. Yes, so don't commit crimes. That doesn't mean we shouldn't exempt you from the system just because you might be guilty if you tell the truth. I think that goes against all of our moral principles to say, I won't tell the truth in this court of law where there are procedural safeguards, because guess what? If I told the truth, you'd be able to put me away because I'm guilty. I don't think that's the greatest thing in the world. The second thing we want to talk about, though, is something I want to call argument by disanalogy, because this seems to be half of the case that they're making. Justin gets up here and says, look, we have all kinds of other things that are great about the justice system that involve a similarity with your side. We can do something that says this person can't actually have to testify. For example, if they're going to say something that's really, really biased, we can strike it from the record. Or if they said something to their priest or their doctor, we can get this out of the system. The problem with these things is they all rest on different justifications. And this is what Dan said. Dan said we don't want to deter people from seeing their priest if we think confession is good to someone's psychological health. We don't want to deter people from seeing their doctors and describing that their injuries might have been something related to a crime or something that might incriminate them or embarrass them at the very least, because we want to have people in society feeling comfortable going and getting these important treatments. These things don't hold about an inner monologue, as Mike said. It's not like people are going to be afraid to tell themselves things in their own mind, or talk to themselves in their own room because they might have this problem. Clearly, an inner monologue is something completely different and unreachable by preferencing this. So the only distinctions they make are just falling back in rhetoric. Like Mike concludes his first point by saying, that would be kind of whack. Or Justin gets up here and says, it's just dumb to say that these things are the same, but they haven't really told you why. If we're willing to accept that you can ask someone to give up their blood, to stick a needle in them and put them into jail because of what their blood says, if you're willing to look at all these other kinds of things, I don't really see why there's any meaningful difference here. The final thing I want to talk about is this idea of benefits. Because we say that we're going to get more people behind bars, and this is a very, very valuable thing, and we're not really going to hurt innocent people. The only justifications they've tried to make against innocent people are twofold. The first is that people are going to look really uncomfortable, and they might actually incriminate themselves just by being nervous or something like that when they go up there in the stand. This is not a sufficient reason to treat these people differently than anyone else, unless you believe their silly argument that when more is at stake, that somehow means that someone should have a harder time of being convicted. But we don't really believe in that principle. Clearly, if your brother or whoever was testifying in favor of you was someone who seemed really, really shaky, that doesn't mean they can get a free pass on being cross-examined. This is a problem that holds across the board, and they haven't explained why this is different. The only real explanation as to why it's different comes at the beginning of Justin's speech. He gets up here and says, defense witnesses might be afraid to testify because the prosecution might start asking questions about them that would incriminate them. Therefore, the defense will have a very, very hard time ever mounting a case. The first response I want to give to this is just the important idea of relevance here. In the same way that you can't just ask someone, oh, by the way, are you also a shoplifter, or something that has nothing to do with the reason why they're indicted, you can't just start grilling the guy who's a defense witness on anything about why they might be there. But the other thing I want to say is it's kind of silly the impact that Justin tries to take away from this. It's as if I could actually ask these people all kinds of questions as a prosecutor who are defense witnesses, they're going to be forced to give these details that might make them look bad. As if what's really going to happen in society in Justin's ideal world is like, I get up there and say, look, I'm a witness for Justin. All I'm going to tell you about Justin is that I was there, but he didn't do it. I'm not going to tell you anything else, because if I do, that's going to look really, really bad. Clearly, that's not the kind of thing that's going to happen. It's not like you're going to lose all of this dialogue or, lose all of these witnesses. When someone gets up there to be a witness, they're going to describe things. They're going to say things that reveal that they might have had something to do with this. The way we get around this is we have relevant standards and standards that the jury and the justice system have to meet before actually indicting these people and questioning them individually. And if we do get the opportunity to do that, if this leads to something, that's fine, but we don't think you're going to just deter all these people from testifying in the first place. So for all these reasons, I think we've shown you that it's not totally whack to have this idea, and that it isn't just dumb, and that there are a whole lot of meaningful differences between losing this information and all of the kind of great things that are separate ideas that they talk about. So for these reasons, we're proud to propose.